This courtroom session starts off looking routine, but within minutes, things spiral into confusion, financial disputes, and a judge who is clearly not in the mood for excuses. We've got disputed payments, missing money orders, and later, a defendant who might have shown up intoxicated to court twice. And if that wasn't enough, a property battle explodes with accusations and a judge ready to shut it all down. Trust me, you're going to want to see how all of this unfolds.
Appearing on behalf of Granite Televalley.
I see. I can't even read my own writing, but you must have been on Zoom and you couldn't get on Zoom. I adjourned it a week. Did you two listen to and understand the rights? Okay, let's start with you. Ms. Sanchez, you listened to and understood the rights? Do you wish to speak to a lawyer? Do you intend to apply for funding?
Sure.
Ms. Kilgore, did you listen to and understand the rights?
Yeah.
Do you wish to speak to a lawyer? And you're saying you've applied for funding, Ms. Sanchez? With who?
DHS.
When did you guys submit that application?
Submitted this morning.
Did you bring it to the court?
Verification on my phone. They didn't.
You're gonna go down the hall and show probation. We're gonna adjourn this to February 20, not probation, to the civil department. February 23rd at what time, Linda?
9 o'clock is good.
At 9 o'clock, okay? Go down, you have to provide them with proof of that right now.
Oh.
You come back. Mr. Capitan, what is the total amount owed?
Oh,
I don't need to hear a breakdown now.
All right, right. The total amount owed is $4,300.
Right here, the judge is doing something very important. He's establishing the financial stakes early. That $4,318 figure isn't just a random number. It's the total alleged debt, and everything that follows hinges on whether that amount is accurate. But notice the tension already building. The defendants immediately push back, claiming over $1,000 was already paid. This is where cases often turn messy: documentation versus claims. So here's the question. Who do you trust more in a situation like this? The company with records or individuals claiming proof through money orders?
$18.92.
So ladies, you better get moving on this. They're not gonna give you that kind of money, I don't think.
No, sir. We are actually disputing $1,027 with that. Taylor Valley received $1,027 in money orders from us on the 27th of November. And they called us, I believe it was about the 20th of January, saying that the money orders went non-sufficient funds. So I contacted.
Do you know anything about that, Mr. Capitan?
Your Honor, I do not know anything about that at this time.
Who's this?
However,
You're from Granite?
Yeah.
Come on up here. Your name, ma'am?
Suzanne Brandon, Granite Televalley. I brought all the correspondence on those NSL money orders.
How do you get a money order? I thought you had to pay for a money order.
You do, and
How
I
can that-
requested them to find out who signed them. It says that they were cashed out.
Where you're in possession of, well, but wait a minute.
It's gone through 2 banks, and they both came back in 7.
Where'd you get those at?
I got them at Myers, their Western Union.
Okay, hang on.
Now this is where things get interesting. Money orders are typically considered secure forms of payment, so when they suddenly bounce or show as non-sufficient funds, that raises serious red flags. The judge is clearly skeptical, and for good reason. Either there's been a banking error, fraud, or someone isn't telling the full truth. And notice how quickly credibility becomes the central issue. Here because, in court, once your credibility is damaged, everything you say after that is questioned. So what do you think happened here? Banking glitch? Or something more suspicious?
Hang on,
Contacted Western.
hang on. Don't slow down. Go back to Meyer.
Oh, we did. They could not help us there at the Myers.
You're gonna have to figure this out. I don't believe this lady would be in here telling me that they were NSF checks if they weren't NSF checks. If she did that, she knows she would have absolutely no credibility with me until I leave this bench. You understand what I'm saying?
Yes,
So you're gonna have to go over and figure it out. Something happened.
we've already been doing that. We received copies of the checks from West.
This moment right here is critical. The judge is laying down a hard line on credibility. He's essentially saying, if the representative lied, her entire case collapses. That's a powerful statement, because judges rely heavily on trust in testimony. Once that trust is broken, it doesn't just affect one claimant, it can destroy the entire argument. And notice how he doesn't jump to conclusions. He sends them out to verify. That's textbook judicial restraint, but with a clear warning attached. The judge now simplifies the math and. This is something courts often do to cut through confusion. He calculates the adjusted balance and puts responsibility squarely on the defendants. No more ambiguity, no more back and forth. Just a clear number and a clear expectation. This is where many defendants realize the seriousness of their situation. Because once the court defines the amount, the next step is enforcement. Would you be able to handle that kind of financial pressure under a deadline?
Oh, so that's all.
And where do we go to submit the proof for assistance? You told us to go submit proof for assistance that we applied for?
Oh, I'm sorry. Sorry about that. You're gonna go down to the civil department. All right, thanks. Which one's Mr. Bodges? You're all set, ladies.
Here.
Which one does he have again? Who drove here?
She did.
Does he have a bond, Heather? I want you to call Heather.
Yeah, I think.
Okay, you want her to pop on again?
I do.
Okay,
Okay, ladies, you can go out in the hallway and talk, okay? I don't know what you're doing, Mr. Bodges.
I'm ready to be down good. I would have.
You don't go yelling like you did at me last week on here. You got me. No. You don't do that. I don't care if you've had 49 vodka tonics or whatever else. You don't do that. Now you show up drinking again,
Yesterday.
Mr. Bodges.
Yes, sir.
Alcohol basically dissipates at the rate of 0.125 per hour. That means if you stopped drinking at 11:30, you were somewhere in the neighborhood of about a 2.0. I can do the math easily if you're interested in an exact reading. So if you're telling me you haven't drank since yesterday, then you were.
And just like that, the focus shifts completely from financial disputes to personal conduct. The judge brings up alcohol consumption, and not casually he's calculating blood alcohol levels in real time. That is a huge red flag. Showing up to court under the influence can seriously damage your case, and in some situations, it can lead to immediate consequences. The judge is clearly connecting behavior to responsibility. Handy's not impressed.
Were highly intoxicated before you went to bed. And that's your prerogative. If you don't have a bond condition that says you can't drink. Heather, I would like you to check and see the felony that Mr. Bodges has, whether or not he has a no alcohol provision in there.
What is the first name, Judge, on him?
Ronald, R-O-N-A-L-D. We burned it over. I don't remember. It's a felony. I don't remember if I
Okay,
did.
okay, that's why I'm looking at. Okay, so it's a bound over case.
Right.
With Judge Hessen?
When did we When did this get bound over? Just
Did your
recently?
case get bound over from district court, Mr. Podges? When were you in district court on the felony charge, sir?
Before
Was
here,
it?
I wasn't making.
I didn't ask you that.
Oh,
I didn't ask you.
I'm sure. Told me maybe.
October, he
Yep.
thinks.
No, Your Honor, I think it's November
Oh,
3rd.
I do see one in here that was bound over on November 18th.
Was that mine or Judge Hess's?
This one was yours.
Is there a no alcohol provision in that?
Let me take a look on this one. Yes,
That's what I thought. John, I'm not gonna swear you to an oath. You took a PBT reading this morning on Mr. Bodges, right?
Yes, Your Honor.
State your name.
It's John City.
I didn't mean to stump you.
Yeah, that's how to think about it for a minute.
Point oh eight eight he had, right?
Yes, Your Honor.
Okay, so I think probation needs to notify, or somebody needs to notify the courthouse, whatever judge is assigned, that Mr. Bodges showed up here. And this is the second day. He smelled of alcohol last time. I didn't have him tested last time, which I guess was last Tuesday or on the 27th. So, I don't think you can handle this case while you're drunk, Mr. Bodges.
I'm looking for a return right now. I got a call two of them last week. Four of them last week. I too poor for legal aid and made too much for paid legal aid. So I called a couple personal lawyers. And I just got paid at first.
You're to come here without drinking next week. That was what I told you to do when I set the bond on that case. Now you got a now according to her, and I'm not going to get into this, you got a felony. What's the charge again?
that charge was, let me make sure. There was three counts. The first count was assault with intent to do great bodily harm, less than murder. Count two, assault with dangerous weapon. And count three, assault with dangerous weapon, felonies, assault.
So you got a 10-year felony and two 4-year felonies pending.
Yes, sir.
And you're
That.
and you're violating a judge's bond conditions. Now, if I had jurisdiction, I'd lock you up right now. Once I sign that bind over certificate,
This is where things get serious. Felony charges, bond conditions, and potential violations all collide. The judge is pointing out that if he still had jurisdiction, this could have resulted in immediate jail time. That's not just a warning, that's a near miss. And it highlights something crucial. Bond conditions are not optional. Violating them, especially repeatedly, puts everything at risk. So let me ask you, should the system be stricter in situations like this?
don't have jurisdiction, which is why we're going to notify the court. Counsel, I'm adjourning this 1 week. If you come here, I'm giving you a PBT again. You understand?
Yes, sir.
And next time, I'm not going to adjourn it. There's going to be consequences for you showing up here like that. I'm going to adjourn it 1 week to February. What do I have? The 9th, is it?
Yes, February 9th at 9:30, Your Honor.
At 9:30 in the morning. Ma'am, did you drive here? You're not going to let him drive, right? Because that would be a crime. Okay? That's all I can do, Mr. Capitan.
Thank you.
You need to straighten out your life. Good luck. Thank you. What is this? Your name, sir?
Yes, it's which road, Austin,
All right, counsel, what is your allegation here?
Our allegation is that the property has some damage to it that threatens my client's investment after an inspection from foreclosure by
What
advertisement.
happened? They bought it at a mortgage foreclosure, right?
Yes, my client did that. We inspected the property. We found some
Redemption period expired, right?
Not yet, Your Honor. We inspected the property and we lost track of Mr. Dawson and communicating with him about some issues we found with the inspection. And so we filed this action. Really just like to talk to him again, to make sure that everything is still okay with the property.
When did the mortgage sale, the foreclosure sale take place?
October 16th, Your Honor.
So you guys wanted termination on the basis that there's language in there that says that the property has to be kept in a reasonably habitable manner, and you want a immediate writ, is that right?
Not exactly at this point, Your Honor. I think my client just wants to be able to re-inspect the property after the initial inspection and ensure that the issues that we found at that initial inspection have been taken care of.
Come here, let me talk to you a second. I hate these, by the way.
I know you do, Your Honor.
Well, I think any judge worth 5 cents hates these. I mean, you're saying bring your exterior ingress / steps to code at back door?
Yes, Your Honor.
Is that the main complaint?
That is the main complaint, Your Honor.
That's ridiculous. I want to know if there's a judge around, and don't tell me now on this YouTube here. Don't tell me now if there's, I don't, that is ridiculous. That was not the intent of this statutory language. And
Now we shift into a completely different legal battle, but just as intense. This property dispute revolves around something that sounds minor stairs, but legally, it's about habitability and rights during a redemption period. The judge clearly sees this as an overreach. And honestly, this is where legal strategy can backfire. Pushing too hard on weak claims can frustrate the court. Timing and substance matter just as much as the law itself.
unless you can tell me something else, what's wrong with the code? What's wrong with the steps? Can you tell me?
No, yeah,
I'm dismissing your case unless you can tell me something real quick, Mr. Devlin. I hate these. And I'm not the only judge that would hate these. It's ridiculous. They get the property and they can't wait to get their hands on it. These people still have the right to redeem the property. What do you have to say? Anything else? Otherwise, I'm dismissing this.
Your Honor, the stairs don't exist.
What's that?
The stairs don't exist. It's not, there are no back stairs and there is.
I'm dismissing your action. You guys can take an appeal.
Understood, Your Honor.
Do you have any stairs in the back?
no stairs on the compound.
How long is, when you bought it, were there stairs on the compound?
No stairs on the compound. Bought this
When did you buy it?
2023 of 12/26. 12/26, 2023.
Are you gonna be able to redeem this property?
This is why I am here today, Your Honor, because I wanted to alert you that I have had no right or statutory right for redemption. And so
Wait a minute.
Yes.
Wait a minute. I don't have anything to do with the sales that happened.
No,
No,
the deed
I want
is-
you to listen to me. son.
okay.
Okay? I don't have anything to do. All they come to the district court for is to ask us for possession of the property when the redemption period is passed. In this case, they're coming to us and asking us for redemption, early writ being issued, I should say, and executed upon, in this case, because of the violation of the code that you don't have any stairs. That's what they're doing. You're gonna have to talk to a lawyer about how to redeem it. You're gonna have to figure out what the redemption amount is, and you only got so many days. I don't know when he said, but you gotta get to a lawyer real quick. Who's this with you?
Oh, that's my fiance.
Well, you're okay, ma'am. You can sit there, but do you understand what I'm telling you?
Yes, yeah.
Mr. Devlin, if I'm being too harsh, you can tell me, Judge, I think you're too harsh and I want you to be heard, and I'm going to let you be heard. And it's okay. We could agree to disagree. I just get tired of mortgage companies salivating, or the buyers of these foreclosures salivating to get the property early. It's like they don't have any, they have no patience on it. They think they can write their own rules. These people moved out. I get all this nonsense. So tell me why I'm wrong in looking at it this way, and I'll trust you're going to be respectful. I'll be happy to listen.
The judge is not holding back here. He's calling out what he sees as impatience and, possibly, exploitation by property buyers trying to fast-track possession. This is a deeper legal principle at play. Redemption rights exist for a reason. They protect individuals from losing property too quickly, and the judge is making it clear he's not going to let procedural tactics override fairness. Do you agree with this stance, or should buyers have more power once they purchase?
Your Honor, I think that the primary concern in this was the lack of communication from the defendant to us after we found the issue with the property. If you're trying to make a judicial determination that the damages that we're alleging don't arise to the level required for termination of the redemption period, I respect that. That is a finding of fact that is your job in this case. However, we were trying to get back in touch with the defendant who became non-responsive to us.
You're going to work on getting that taken care of, though, right? Listen,
Hey.
you got to have, you should be working on getting that taken care of and working on getting the property back. What is the redemptive amount? Can you tell me, Mr. Devlin?
I can give you a general idea, Your Honor. I'm going to guess that this was a condominium foreclosure, as the amount is under $10,000.
I'll figure out a way to get the money together.
Your Honor, I would calculate
Hang
the
on.
redemption period is April 16th.
Listen, figure out a way to get $10,000. I don't care if, listen, can you do that? You don't want to lose this property.
No, not at all. I haven't really had an opportunity to, because what I'm here for is,
Sir, they're asking for an early writ. They're asking me to accelerate the redemption time period and saying, give us the property back. He's let the property become uninhabitable or, now, wait a minute. Everybody wants to raise their hand out here. Just let me finish. Talk to a lawyer. Talk to Mr. Devlin. He's saying you can redeem the property for somewhere less than $10,000. You have until April 16th, right, Mr. Devlin?
Your Honor, that's my guess based off this being a 6-month redemption, which is usually what a condominium is. I don't have the sheriff deed up in front of me. I'm on my phone right now. Tough
Yeah.
for me to flip around.
Double check. I don't think I do either. Maybe I
Yeah.
do.
You should have it, Your Honor. Here, I'll verify.
Yeah, it is October 16th.
October
Listen.
16th is the sale, so
Listen.
yes, April 16th is the redemption.
Get the money together. Get the money together so you don't lose all the equity in the property, okay?
yeah,
All right. I'm dismissing this action.
Your Honor, do you need me to submit an order?
Pardon?
Do you want me to submit an order?
Please.
Will
Please.
do. Will do, Your Honor.
Thank you. Good luck.
Have a good
I'm
day.
helping you out. Go get the money to redeem the property, okay?
get in contact with, Attorney Devlin.
Yeah, but get the money together. You might want to talk to your own lawyer. I don't know what your financial situation is. You can call Attorney Devlin and speak to him.
Absolutely, Your
Okay?
Honor.
Good luck. Thank you.
Thank you, Your Honor.
Thanks, Mr. Devlin. Golden Management versus Cindy Davy, and all occupants 26001. Name?
Stephen Summers.
Your name, ma'am?
Mrs. Summers.
Ms. Tucker, I don't know why you sent all this over the weekend. I mean, I gotta have a chance to read this. I can't. Your name?
Wendy Tucker Beck.
I mean, how am I supposed to read all this? And
I apologize, Your Honor. I have counsel here with me today.
who's your lawyer?
I've retained the law offices of Aaron Cox, I believe.
Where's Mr. Cox
attorney.
at?
I believe Miss Attorney Saab is standing in for him today.
Your Honor,
correct?
if you may just pass.
I'm sorry?
If you just may pass on this matter briefly while I conclude in another court.
3 days to pay all of it.
Yeah, I'll do that.
Thank you, Your Honor.
And
Well, you guys can all stay put. You can have a seat. I'm done with Hidden Oaks. We have this Tucker one, and then I have the Butler one. And the property address is where? It's on Grange? I might just have to go over there before next week. Maybe I'll go over there. Ms. Tucker, you hang out until Mr. Soap gets ready. I'll pass your case. You folks can have a seat right at the table there, okay? Right at the table.
Thank you.
If your son is ready.
All right, let's go ahead. Wendy Tucker Beck versus Stephen and Lisa Summers, 2605336. Everybody's name again. Sir, your name.
Stephen Summers.
Ma'am, your name. Mr. Soap, do I have an appearance from you?
I'm on behalf of Aaron Cox, Your Honor. Yes, we did submit an appearance.
We have an appearance, Linda or Jennifer?
Yes, we do, Your Honor.
So, counsel, I'm trying to go through this, and I don't know what this is about, but let me tell you some things that trouble me. I just received all of this. They apparently Ms. Tucker Beck sent it in Friday and today. I don't know what I'm looking at here. It says, or was it Judge Hessen? There were both my friends. I don't know who I'm supposed to be friends with or Judge Hessen's supposed to be friends with.
Your Honor.
Hang on.
I
Thanks,
didn't-
Derek. Landlord tell Rockwood Police and Judge McNally that. See you soon. Where is this all coming from?
That's stuff that I,
Well,
and that was, some text messages, they didn't.
I don't like my name being mentioned, and I sure don't like people.
That was sent to us via text message from the landlord that works for her.
That works for Ms. Tucker Beck?
Correct.
Who's that? Who's your who am I supposed to be friends with this time? I mean, I got so many friends that hold me out as their friends. If I had half as many friends as purportedly are my friends, I wouldn't be at a district judge. I'd be the president. What is this? Is this Mr. Loringer?
Yes, sir.
Mr. Loringer, I don't know outside the building. He used to come in front of me quite a bit. Mr. Sobe, let's cut past this. I just don't, it just alarms me when I start hearing I'm friends with people that I don't even know. And I've heard enough of that lately. But listen, what are we going to do about this? I didn't have a chance to review any of the documents. You sent a slew of documents here. I don't know what I'm going to do with all of these. I mean, I'm certainly not reading them, speed reading them now.
If I may, Your Honor, this is a second hearing. I was made aware of a certain settlement offer that I'd like to present to the defendants. If I may do that, and I don't know if you want me to do that in a private breakout room or.
Yeah, I shouldn't be privy to settlement discussions. I shouldn't be at all. So,
if they have a phone number, I would be more than happy to give them a call.
You guys want to give them the call? Give them the number? What is it?
586. Oh, I don't know.
Was it in the car?
Maybe 248.
248.
416.
416
0737.
0737. Call them. I'm getting off the bench again. Yeah. We'll go from there. Okay.
Okay, I'll give him a call. Your Honor.
Thank you. You guys go outside or someplace quiet here and talk to the lawyer. Okay. And then you come back in.
Yes, Your Honor.
Name.
Wendy Tucker Beck.
Your name.
Stephen Summers.
Your name.
Lisa Summers.
Did you guys resolve this, Mr. Sob?
We have, Your Honor, I spoke to the defendants. Both of them have agreed to a consent to convert this into a termination of tenancy matter and to set the writ date as February 23rd, 2026.
And you're abandoning any money judgment?
Yeah, we are going to remove the money
You're
judgment.
simply agreeing to that they're going to vacate by the 23rd.
That's correct, Your Honor.
Mr. Summers, do you agree to that?
Yes, sir.
Ma'am, Ms. Summers, do you agree to that?
Yes.
So you understand that this is going to convert to a termination of tenancy. No matter what happens, you have to vacate by February 23rd. If you don't, they're going to present an application for a writ. If you're still there, a few days thereafter, you're going to be evicted. Do you understand that, Mr. Summers?
Sure.
Ms. Summers?
Yes.
Do you agree that Mr. Sob has your permission to sign your name to this proposed consent judgment?
Yes.
Well, Mr. Summers?
Yes.
Ms. Summers?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside this proposed consent judgment, and you also have 10 days to appeal. Do you understand that?
Yeah.
All right. So you understand you have to vacate, right?
Yeah.
Okay. Ms. Tucker Beck, and you're satisfied with this agreement?
Yes, Your Honor, as long as they comply with the date.
You have to
and-
get out by then, otherwise you're going to be evicted, folks. So you better go back and start packing. Okay?
Okay.
Okay.
Wish you well. Thank you, Mr. Sob. Thank you, Ms. Tucker Beck. Have
Thank
a
you, Your
good
Honor. Have
day,
a great day.
everybody. All
Thank
right.
you,
we're-
Your Honor.
Holmes case. What? Oh, I'm sorry.
This courtroom session delivered multiple legal battles, each highlighting a different aspect of the justice system. From disputed payments and credibility issues, to serious concerns about courtroom behavior and bond violations, and finally, a property dispute where the judge firmly defended redemption rights every moment, reinforced one thing: accountability matters. The judge's rulings emphasized fairness, responsibility, and the importance of evidence over claims. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.